Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. As we had previously reported in our coverage of the Idaho versus Kohberger case, there were multiple hearings that were held behind closed doors. There was a gag order that was in effect in one form or another until after Mr. Kohberger pled guilty. And then there were numerous documents, particularly evidence, filed under seal and withheld from public disclosure, sometimes by stipulation, agreement between the state and the defense, other times initiated by the defense or the state. This case was deemed closed 6 months ago, and it is still largely sealed from the public, but for a handful of documents that were ordered to be unsealed months ago from the end of the case, April and May, June and July 2025. That is it. Everything prior to anything released for the month of April 2025 back to the beginning of the case, which was December 29th, 2022, remains under seal as of this date, January 21st, 2026. No one else was ever arrested. There's never been any whisper of a co-conspirator, alternative perpetrator, accessory before the fact, accessory after the fact, and certainly no one has ever been charged except Mr. Kohberger. Questions continue to be asked. Why is this case still so sealed? 6 months after the only person who was ever sent to prison, why is this case still sealed? For the second time in 3 weeks, information long sealed from the public was released and then removed without any explanation. It happened the first time on December 30th, 2025, when documents Judge Hippler ordered to be unsealed from the third court order issued 98 days ago on October 16th, 2025, with rulings on the documents, some over one or both sides' objections, coming out on December 18th, 2025. A few documents from the end of March 2025, ordered by Judge Hippler to be unsealed to the public, were removed from the court docket on December 30th, 2025, with absolutely no explanation as of today why that happened. There's speculation as to the personal nature of some of the documents. However, no official word from the court and nothing else ordered to be unsealed has been unsealed pursuant to that December 18th court order, which remains in effect. It has never been amended or rescinded by the court. The second time it happened was yesterday. The Idaho State Police released a large quantity of photographs from their investigatory files and then removed them, again with no explanation. The entire batch, just like all of the records from the December 18th court ordered to be unsealed, were removed. No explanation from Idaho State Police. Ladies and gentlemen, I would like to read a portion of a United States Supreme Court case, Richmond Newspapers Inc. versus Virginia. 448 U.S. 555 is the beginning of the case. It's from 1980. It addresses why trials must be open to the public under not just the First Amendment, but the 14th Amendment to the United States Constitution. If you go to page 575 through 578 of this United States Supreme Court case, you will read, the freedoms of speech, press, and assembly expressly guaranteed by the First Amendment share a common core principle of assuring freedom of communication on matters relating to the functioning of government. In guaranteeing freedoms such as those of speech and press. The First Amendment can be read as protecting the right of everyone to attend trials, so as to give meaning to those explicit guarantees the First Amendment right to receive information and ideas means in the context of trials, that the guarantees of speech and press, standing alone, prohibit government from summarily closing courtroom doors, which had long been open to the public at the time the First Amendment was adopted. Moreover, the right of assembly is also relevant, having been regarded not only as an independent right, but also as a catalyst to augment the free exercise of the other First Amendment rights with which it was deliberately linked by the draftsman. A trial courtroom is a public place where the people generally and the representatives of the media have a right to be present, and where their presence historically has been thought to enhance the integrity and quality of what takes place. As of this date, not a single document ordered to be released over a month ago on December 18th, 2025, relative to the court order that went out to both sides on October 16th, 2025, asking for their objections and non-objections to the release of multiple documents from January, February, and March 2025, including evidence under seal relative to multiple motions in limine, still has not been released to the public. Till next time, this is Kathy. Thank you for joining us here today.